Okay. I I very warm welcome to my YouTube channel VaJee. My motto is Center for Legal Excellence. Okay, here I am simplifying Bharatiya Sakshya Adhiniyam for you, and I'm just making you understand by the way of objectives, because prelims, what we face objective questions, and they're not bit of need a concept clarity, but you should have mastered these objective as well if you want to really qualify those exams, because in a limited time you need to be very witty. Otherwise, maybe you are very well versed with concept, but a minor mistake or minor slips just bring out of you that race which we always dreamed of running. So without any further delay, let's begin with. Okay, here is our first question. According to section 1 subclause 2 of Bharatiya Sakshya Adhiniyam, the act applies to proceeding in court martial. However, to which of the following proceeding does not explicitly not apply? This I'm just read this question and go through these options and pause a video and answer it. To answer it. Okay, if you're able to answer, well, fair enough. If you're not, I'm here to explain. Okay, so what is this question? Simply ask you ki application of BSA. What is application? Where it applies. Okay, this asks simply this question. Okay, so 1 subclause 2 deals with specifically, 1 subclause 2 specifically deal with it ki where it apply or where it not apply. It simply says that earlier in Evidence Act, what we happen, it doesn't apply to Court Martial Act because there are specific acts to govern it, but now it is specifically included ki okay, court martial is also come within this jurisdiction and it's going to be applied here. But what is still it's out of its jurisdiction is proceeding before arbitrator. Okay, proceedings before arbitrator, it doesn't apply. Why? Because there is a separate arbitration act, and it's basically a private proceedings, and it's bring with the intention to simplify litigation. If we are going to apply a Sakshya Adhiniyam in this only, so how it going to be simplified? Because trust me, it's a very consolidated act, but not simple. But we are here to make you simple, make that simple for you. Thank you. Okay, so it doesn't apply to arbitration. What else? It doesn't apply affidavits. It doesn't apply to affidavits. Okay, affidavit, why it's not apply on affidavit? Because affidavit, it's basically opinion. You state in an affidavit na ki so and so para I state that ki that is true as per my knowledge and opinion, and opinion cannot be taken as a evidence, and that is not a criteria to hang someone. Your opinion matters for you only, but not for the court. Okay, and further what it says, फर्दर इसको स्ट्रेंथन मिलती है सेक्शन 2(1)(a) से, विच डिफाइन कोर्ट. कोर्ट स्पेसिफिकली डिफाइन करता है कि विच इंक्लूड्स ऑल द जजेस, मजिस्ट्रेट एंड पर्सन legally authorized to take evidence, but it does not includes arbitrator. It is specifically again includes excludes arbitrator. तो हमें आर्बिट्रेटर को उसने कोर्ट की डेफिनेशन से भी अलग कर दिया, यहाँ पे भी इसने अलग कर दिया कि भाई आर्बिट्रेटर हमारे उससे नहीं आएंगे. मतलब ऑल्दो वी हैव अ CPC प्रोविजन कि वी कैन रेफर टू आर्बिट्रेशन, कोर्ट कैन डायरेक्ट फॉर आर्बिट्रेशन टू एनी मैटर, बट for criminal proceedings, for the purpose of evidence, arbitrators and the proceeding before arbitrator are not within this jurisdiction. Okay, and our next question is section 2 of Adhiniyam. If a fact is declared as a conclusive proof of another fact, what is mandatory action for the court upon the proof of the first fact? Here are your options as well. Okay, kindly pause our video and read it. And what's its answer? The court shall regard the other fact is proved and not permitted evidence to disprove it. It basically conclusive proof in Bharatiya Sakshya Adhiniyam section 21B deals about it. Section 21B deals about it, what is meant by conclusive proof, and what it says. According to Act, when a fact is declared as a conclusive proof of another, court must, on the proof of one fact, regard the other fact as proof. It's clearly given in a definition. There is nothing to much discuss about it. When one fact is proved, conclusive proof of one fact, it means ki other fact is also proved. Court wouldn't ask for a further evidence. So this is the veracity of conclusive proof. When you conclusive proof a fact, that matter ends here. No further proof required. Court cannot ask you. Okay. Next question is, how does the Bharatiya Sakshya Adhiniyam differentiate between the fact that is disproved and the fact which is not proved? They are basically asking about you a fact. एक फैक्ट है जो प्रूव हो गया और एक फैक्ट को डिसप्रूव हम कब मानेंगे? व्हेन वी आर गोइंग टू से दैट कि नहीं, नाउ दिस इज डिसप्रूव, नाउ दिस इज प्रूव्ड. लेट्स से disproof is defined under section 2(1)(c) and the proof, it's not proof, it's 2(1)(i). I may define what is not proof. What it says कि to see a disproof when a court, after considering the evidence, after considering the evidence, either believe it does not exist or finds its non-existence so probable that a prudent man would act on the presumption it is false. Okay, कि एक प्रूडेंट, यहाँ पे जो स्टैंडर्ड अप्लाई हो रहा है दैट इज ऑफ अ प्रूडेंट मैन, कि एक रीजनेबल लॉजिकल ह्यूमन बीइंग का स्टैंडर्ड अप्लाई कर रहे हैं. कि अगर वो मानते हैं कि नहीं यार ये क्या बकवास है, ये थोड़ी ना ऐसे एग्जिस्ट, मतलब ये एग्जिस्ट नहीं करता है, मतलब प्राइमा फेसाई आपको जो लग रहा है, ठीक है. तो कोर्ट मतलब आफ्टर कंसिडरिंग द ऑल एविडेंस, कोर्ट ने एक ओपिनियन फॉर्म कर लिया कि नहीं भाई ये फैक्ट एग्जिस्ट नहीं करता, वॉट एवर यू आर सेइंग आई एम नॉट इन एग्रीमेंट. तो दैट फैक्ट्स डिसप्रूव. एंड व्हाट इज नॉट प्रूफ? Not proof represent the state of legal inconclusiveness. What is legal inconclusiveness? One person asserted a fact and another person denied that fact, but both are not able to give sufficient evidence. The court neither believes that it exists nor it believes it doesn't exist. Means you stated something but you don't have anything to prove that, or you not tendering a sufficient evidence, then that inconclusiveness lead to a situation which is not proof. This proof is clear cut a legal conclusion कि ultimately whatever you are saying court is not agreeing with you. But in not proof case what happens कि person is not able to convince a court कि that fact is exist or not exist. Okay. Our next question is, which of the following would be considered a fact under 2F of the Bharatiya Sakshya Adhiniyam but not a document under 2D? You know, fact is defined under 2F, document is defined under 2D. Okay, so here read all the options and just tell me the answer. Which of these option is fact plus document? Okay, let's see the answer. Okay, a person intention to act fraudulently, it's a fact. Okay, sorry, question is that ki which is fact but not a document. Okay, so answer is a person intention to act fraudulently. intention to act fraudulently is classified as a fact because the legal definition includes a mental condition of which a person is conscious. However, it's not a document. Why? Because document defined as a matter recorded upon any substance such as paper, metal, even digital storage using letter, figure, marks or electronic means. While document can serve as evidence of intention, the internal mental state itself cannot itself remains a psychological fact rather than a recorded substance. Okay, so that is a psychological fact. It categorizes as a psychological fact. You cannot record as a documentary evidence because to be fall in a definition of documentary evidence, it's a specifically recorded with the intention to use as a evidence. Or your mode of recording can be either ways, or your medium of recording can be with n number of ways, but with the intention of using as a evidence. Here this is not. Okay, let's move to our next question. A key distinction between the court action under may presume provision versus shall presume provision. क्या होता है कि डिस्टिंक्शन क्या है मे प्रिज्यूम एंड शैल प्रिज्यूम में? हम बेसिक डिस्टिंक्शन है. what it is, under may presume the court has discretion to ask for a proof, while under shall presume it accept the fact as proof until rebutted. Okay, we know that ki presumption is of two kinds, or presumption of two kinds. One is rebuttable, another is irrebuttable. Okay, rebuttable may presume and shall presume, both are fall in that category only, and irrebuttable presumption are conclusive proof, the fact conclusive proof. And but what is differentiation between two, may presume and shall presume? Level of discretion. If something in a code written as may presume, so what it means कि court has a discretion, it may consider as a proof or it may call for a further evidence. But where it is written as shall presume, court bound to presume that fact, but party can have a liberty to give evidence to disprove a fact. But in conclusive proof, party doesn't have that liberty. Hope I am clear. Okay, let's move further towards our next question. Next is in the trial where the defendant state of mind is a critical, the witness testified that defendant acted in a good faith according to section 2F of Adhiniyam. What is the legal nature of this statement about good faith? Okay, here are your options. Kindly pause a video for a second and just go through these options. Okay, let's see an answer. Okay, it is a fact, because as earlier I told you na कि fact any mental condition of which person is conscious. Everything we are conscious of, it's a fact. ठीक है? Like in a good and illustration, if I'm right, so it's illustration number 4 to 1F, illustration number 4, which specifically include this, keep good intention and fraudulently or are considered as a fact. So if you go through a once illustration, you have better understanding. Just go through once that illustration, particular to 1C or to 1F में illustration 4th illustration है. Okay, let's move towards next question. The definition of proved in section 2J relies on the standard of a prudent man. This standard applies that court belief in existence of fact must be. Just pause the video, answer it. Let's see the answer. Answer is based on the probability that would lead to a reasonable person to act upon that belief in their own affairs. Okay, so as I explained earlier, what standard of proof is laid down by Adhiniyam. दैट इज अ रीजनेबल प्रूडेंट मैन. मतलब बहुत ज़्यादा आपको रेशनल और प्रूडेंट एंड जूरिस्ट होने की ज़रूरत नहीं है. इट वाज जस्ट सिंपली एक मतलब एक कॉमन मैन के जो कॉन्शियस को सेटिस्फाई कर रहा है कि हाँ ये प्रूव हो रहा है फैक्ट, प्राइमा फेसाई देख के लगता है हाँ प्रूव है, प्राइमा फेसाई देख के लगता है नहीं प्रूव हो रहा, या हम इनकन्क्लूसिवनेस में है नीदर प्रूफ नॉट डिसप्रूफ, देन इट्स नॉट प्रूफ. ओके, लेट्स मूव टू नेक्स्ट क्वेश्चन. Based on just this object is all about ki BSA when came into force is 1st July 2024. Okay, let's move further. Our next question is, under section 2G of the Adhiniyam, fact in issue is a fact from which the existence and non-existence of right or liability necessarily follows. In a civil suit for the breach of contract, which of the following would be a fact in issue? Here are your options. Just go through it. Let's see the answer. Okay, simple है. एक civil suit है, damages हम claim कर रहे हैं, उसके लिए fact in issue क्या हो सकता है? पहले तो वो वैलिड कॉन्ट्रैक्ट होना चाहिए ना. दैट इज़ द प्राइमरी बेसिक रिक्वायरमेंट. दैट इज़ योर आंसर ओनली कि वेदर द वैलिड कॉन्ट्रैक्ट वॉज फॉर्म बिटवीन द पार्टीज, कि हमारी कोई राइट है, लाइबिलिटी है, नेसेसरीली फॉलो हो रहे हैं. दैट इज़ अ बेसिक प्राइमा फेसाई इशू इन अ सिविल कोड. अगर आपका कोई बेसिक, अगर आपका कॉन्ट्रैक्ट ही वैलिड नहीं है तो आपका ब्रीच कहाँ से होगा? That is the basic difference we always take. Okay, let's move to our next question. Section 2A defines a court to include all the person except arbitrator legally authorized to take evidence. This implies that, what it implies? Just go through these options. Let's see answer. Okay. A commission appointed by a court to receive record witness testimony would fall under the definition of court for the purpose of Adhiniyam. Okay, so it is very clear from the definition. What it says, section 2A says that court is the functional rather than the restricted to a title. It includes all the person legally authorized to take evidence. Okay, and who is not okay, basically let's talk about functionality कि whoever except the arbitrator legally authorized to take a evidence, then it's a court. मतलब it's not इस तरह की कोई भी कोर्ट है जो स्टैचुरली हमने बनाई है या लाइक ट्रिब्यूनल्स हैं या कुछ भी है, but if they are legally authorized to take a evidence, they are fall within the definition of court. That's why we are classifying commission as a court, because commission is issued to examine a witness and to record their evidence. So they then they fall within this definition. Hope I'm clear. Okay, let's move to our next question. The expanded definition of document 2D now includes the various form of electronic and digital record. Which of the following is the best exemplifies the principle of behind this inclusion? हमने डिजिटल रिकॉर्ड्स एंड डिजिटल एरा जो हमारा चल रहा है उसमें हमने बहुत सारी चीज़ें इंक्लूड की हैं. हमने क्यों इंक्लूड की हैं? दैट्स वी हैव टू गिव एन आंसर इन द स्पेसिफिक ऑब्जेक्टिव. ओके, देन लेट्स सी द आंसर. The medium of storing information is irrelevant. What matter is that matter has been recorded for a potential use as evidence. मैंने आपको अभी section 2D when I explained that document, I explain you this already. Okay, let's move to a next question. Okay, what is the primary purpose of BSA as stated in preamble? Objective क्या है BSA में? Simple. Just go through these options. Let's see the answer. Okay, it simply says that to consolidate and provide a general rule and principle of evidence for fair trial. Okay, ये जो general rules and principle of evidence for a fair trial, kindly mark it, highlight it, because I have seen it's asked in one of recent upcoming exams. Because generally that first time we ignored. and we all remember that previous one, and we get confused, and we're just going to lose a 1 marks question. That's why I'm just suggesting just highlight those preamble lines as well. Okay, sometimes questions are framed from here also. So okay, let's move further. According to section 2 subclause 2, if a word like a digital signature is used in Bharatiya Sakshya Adhiniyam but not defined therein, where should one look for its meaning? Okay, हमें कहाँ पे देखना है? It's just if you know the rule of interpretation, if something is not defined in the act, we can take an external aid. That is what it about. Okay, so he's saying that if not defined in IT Act, take help of it. Let's see answer. It's if it defined in Information Technology Act, we have to just take a definition from here. Similarly, if some word is used here but not defined and defined in BSA or BNSS, we have to take a meaning from there only. That is to create a seamless chronology so that we cannot get confused. Okay, let's move with our next question. What it is? Okay, a statement made by the witness in a court via video conferencing is represented as evidence under section 2E of Adhiniyam. How would this section is classified? We simply know that. Let's see. It's oral evidence. It's clearly mentioned in a definition. 2E first subclause is defining it. It's if a witness making a oral statement by a video conferencing, it's considered as a oral evidence. There's nothing so hard and fast rule. Okay, let's move further. Which of the following scenarios best illustrate the concept of relevancy as defined in section 2K of Adhiniyam? Just go through it once and just answer. Let's see the answer. Okay, evidence of motive is considered because a specific provision in the Adhiniyam connects motive to a fact in issue. Okay, what is relevancy? Can whatever come within the court knowledge can consider as a evidence? No. To consider evidence, it must be a fact which is connected with fact and issue, and that fact and issue should be relevant to a trial. Okay, if it is only relevant, and how it going to be relevant? If it is specified relevant under the provisions of this Adhiniyam, then only court is going to consider. Court is not going to consider every fact which comes under the sun. It's simply we define relevancy in terms of this provision only. If it falls within the specific provision, then only we are going to consider it. Otherwise, however the logical it may be, it wouldn't considered as a relevant fact. It wouldn't consider as a evidence. Okay, just see next question. Okay, in the theft trial, the prosecution present a clear CCTV footage showing the accused committing the fact. The defendant does not challenge the footage. The court, after viewing it, believed the accused committed the theft. According to section 2, the fact of the theft is said to be what it's a conclusive proof, or proof, cell proof, or a fact in issue. That is a factual situation given here, and what under it fall, you have to answer. Okay, let's see the answer. It is a proved. I already told you, proved when the court, after reviewing the evidence like CCTV footage, believes it exists or consider its existence is highly probable based on the prudent man standard. Then we consider it's a proof, clear-cut proof. That what definition says, and that what in this illustration demonstrate. Okay, let's move further. The illustration under section 2G for fact and issue. A murder trial includes that A had received a grave and sudden provocation from B. Why is this considered a fact in issue? I'm asking for a reason. Just go through these options and give an pause the video and give an answer. Let's see the answer. Okay, because its existence and non-existence would alter the nature of A's liability, potentially reducing a murder to a lesser offense. Lesser offense, culpable homicide, not amounting to a murder, because grave and sudden provocation falls under the general exceptions. Okay, so that's why we consider it's a very fact and issue and a crucial fact to determine by the court. Okay, let's move further. Which of the following item based on the illustration in section 2D would not be considered a document under the Adhiniyam? Simple, based on a simple definition. Just go through an options and answer it. Let's see the answer. A witness's unrecorded verbal confession to a police. It's not a document. Okay, hope I'm clear. Let's move further. A court is presented with a situation where a specific provision of the Adhiniyam state it may presume the existence of fact B if a fact A is proven. The party prove a fact A. What are the possible courses of action for the court? Hope this statement is clear. Just go through option once again. Let's see an answer. It can either regard the fact B as proof until it is disproved, or it can demand further proof of facts of B. May presume, go through a definition. You have a better understanding of this objective. Okay, hope I'm able to simplify or just help you to remember few concepts through objective. Hope.